Good morning, ladies and gentlemen. My name is Alexandra Gordin.
And I'm Q Jia Yao.
We are the co-chairs of the 2013 and 14 Peel UK Organising Committee, and we are delighted to welcome you here to our 8th annual conference. Peel UK is the only intercollegiate student organisation environmental law conference in the UK. We are unique in that our members are postgraduate students from universities all around London. Our purpose is to further the understanding of environmental justice and to advocate and strive towards environmental justice for all.
This is the 8th year running, and the theme for this year's conference is Corporations' Role in the Environmental Crisis. Today, our lives, necessities, and luxuries, from food and clothes to medicine and mobile devices, are provided through corporations. And corporations now have a degree of control and influence over our environment which is unparalleled and rivals that of nation states. While this unprecedented growth in corporate power was meant to increase our standards of living, it has brought about a serious impact on the environment. Now, many corporations have started to realize that there is no business to be done on a dead planet. Corporate social responsibility and sustainable development have become mainstream corporate buzzwords. Nevertheless, it remains unclear what these buzzwords entail, and among competing interests, which interests and whose interests should take priority. Today, we are hoping to discuss questions such as, is it prudent for us to let sustainability be defined by corporations? Or, beyond the notion of CSR, should there be a legal notion of public accountability? And does the traditional commercial enterprise existing for continuous growth and expansion need to be reconsidered in a planet of limited resources? So it is through this lens that we invite you to engage with the many interesting issues we will cover in this conference. The aim of a Peel conference is to facilitate discussion from all different perspectives of the spectrum. And we are counting on you, our very diverse audience today, to engage and participate in our sessions so that we all have an enriching experience.
We would like to take this opportunity to give a big thank you to our speakers. We are lucky to have several of the leading lights in environmental law, all volunteering their time. They have traveled from across the UK, Europe, and even as far as Sri Lanka. Additionally, we would like to thank our generous sponsors, without whose support today this conference would not be possible. Green Dragons, City University London, University College of London, London School of Economics, Housefield & Co., and Friends of the Earth. If you haven't already done so, please download our conference app to your mobile device through our Peel website. You go to peel.org.uk/conference. Using this app, you will be able to follow our conference program, see our speakers' profiles, and more. If you are on Twitter, Facebook, LinkedIn, or Instagram, the hashtags for this conference are Peel UK or Peel UK Conference. For some brief but necessary health and safety information, we are not expecting a fire drill today. However, in case of an emergency, the exits are at the back to the right, to the left, and the gathering point will be upstairs, out in the front, across the street. We will be guided there by reception. Finally, without further ado, we would like to introduce our moderator for the panel sessions of today. We are lucky to have Professor William Howarth, who is Professor of Environmental Law at Kent Law School and co-convener of its LLM programs in Environmental Law and Policy and International Environmental Law. Thank you.
Thanks tremendously, Alex, and indeed the whole team for putting together a fantastic program, which was really great, and doing everything that needs to be done by way of an introduction. My life is made very simple. All I have to do is to ensure that things run on time, and since we're already a little bit out of time, I've got to turn the clock back a bit to make that happen. But we'll encourage the speakers to keep to time and look forward to hearing their presentations. And we're off to an excellent start. Bhopal seems to have been around for as long as I've been studying environmental law. which some of you realise is quite a long time. The shadow still hangs over us, and we're being brought up to date to issues which I thought had been resolved but have not been by Tim Edwards, who's a research and information specialist with the International Campaign for Justice for Bhopal. Tim, would you give us your presentation, please? Thank you.
Thank you, Bill. I'm here wearing two hats effectively because apart from the campaign work, I'm also trustee of a UK charity which supports two very extraordinary health centres in Bhopal who are offering free care, the only facilities offering free care to gas survivors and survivors of the second disaster of water contamination in Bhopal. I have to admit at the outset that I feel something of a fraud talking about law in such company amongst such wide-ranging and deep knowledge of the law, because I'm a layperson myself, and whatever I know about the law I've gained through my study of Bhopal. So please bear with me if I make obvious and silly mistakes along the way. The world's worst industrial disaster began at an under-designed and poorly maintained Union Carbide pesticides factory in Bhopal, India, on the evening of December 2nd, 1984, almost 30 years ago, when a large amount of water and contaminants mixed with over 40 tons of the highly reactive, volatile and toxic chemical methyl isocyanate, otherwise known as MIC. MIC carries an exposure threshold limit of 0.02 parts per million, and that makes it about 5 times more lethal than the World War I chemical phosgene, and about 500 times more dangerous than hydrogen cyanide, which was the toxin present in Zyklon B during the Holocaust. As a result of the mix, a rapid runaway reaction ensued in Tank 610 at the pesticides factory. Shortly after midnight of December 3rd, approximately 27 tons of MIC gas and other reaction products jetted from the top of a high smokestack, spread out and drifted down close to the ground in a dense cloud that was carried by prevailing winds straight into the heart of Bhopal city, whose central train station lay less than a mile from the factory complex. 6 safety systems were either inoperative or not sufficient to stop a leak of that magnitude and pressure. Gas survivor and justice campaigner Rashida B described the night of terror that followed. Everyone was running all over the place, shouting, "Run away, we will all die." When we reached Pokta Bridge, our eyes had got swollen and we had so much trouble in our lungs that it felt as if someone had lit a fire in our body. Our eyes started to black out and we found it very hard to breathe. We could hear voices around us saying, "Oh God, please grant us death." That day death appeared desirable. Evidence collected by Amnesty International suggests that over the next 72 hours, at least 8,000 to 10,000 people were killed, with children and the elderly suffering the most. The chief cause of immediate death was pulmonary edema, whereby victims were drowned by fluid produced within their own lungs. Other observed effects were bronchial and nasal lesions, heart attack, spontaneous abortion, blindness, racking cough, concussion, paralysis, and symptoms of epilepsy. By the time the gas had dispersed, some 573,000 local residents had been exposed. Emergency services were overwhelmed. Over the course of the first day, 20,000 people were treated in the 1,000-bed Hamidia hospital alone. The inundation led to corpses being stacked one on top of another like they were bags of wheat. There was no abating the scale of human need. In the first 3 weeks, more than 160,000 people were treated at the city's hospitals, and almost 7,500 were admitted, even though there were fewer than 1,800 beds. And at the time, the lack of toxicological information coming from the company on relating to MIC meant that there were no effective treatment protocols, so people were treated symptomatically. They were given eye drops and steroids and antibiotics. According to subsequent medical research, highly elevated rates of morbidity and mortality continue in the affected communities to this day, almost 3 decades later. There's a long-term prevalence of ocular and respiratory illnesses such as early-age cataracts, diminished vision, breathlessness, persistent cough, and chronic obstructive airways disease. MIC also enter the bloodstream, causing multi-systemic injuries to organs within the body. Chromosomal aberrations have been discovered, leading to expectation of cancers and the possibility of birth defects. In fact, a wide-ranging study conducted by our principal organisation in Bhopal over the last 2 years suggests that birth defects are running at something like 7 times the national average in water and gas-affected communities. We hope to publish that study by the end of this year. Gynecological disorders such as uterine bleeding have been observed, along with high levels of reproductive disorders. Neurological and neuromuscular effects such as body aches, tingling in limbs, dizziness and loss of motor control are common symptoms of gas exposure. Immunological impacts have led to diseases such as TB manifesting at 3 times the national average. Anxiety, memory loss and depression are regularly observed psychiatric effects amongst approximately 30 to 40% of the population affected. Evidence of second-generational effects is now firmly established. Some boys born to gas-affected parents suffer growth retardation, whereas hormonal chaos has afflicted girls. Attempts to provide effective and meaningful legal remedies for this unprecedented abuse of essential human rights have until now met a battery of obstacles. In fact, it's no exaggeration to say that the actions and inactions of state and private actors taken together amount to a concerted conspiracy to obstruct the course of justice. Both Indian and US courts and authorities have, at key stages, played a central role in this process. Few people are aware that Union Carbide's gassing of Bhopal was first a criminal justice issue. Crime number 110484 was registered suo motu by a Bhopal police station house officer on December 3rd, 1984. Less than 24 hours after the onset of the disaster, while hundreds of corpses still lay scattered across the old city. The crime's first information report was registered under 304A of the Indian Penal Code, which concerns causing death by negligence. 9 individuals and 3 corporations were indicated as accused, of which 1 individual and 2 corporations were based overseas. The foreign corporations were Union Carbide Corporation, in 1984 the 35th largest industrial concern in the US, and its wholly owned subsidiary Union Carbide Eastern, based in Hong Kong but registered in Delaware and designed to oversee UCC's equity and interests across the Asia region of its worldwide operations. Union Carbide India Limited, or UCIL, a 50.9% majority-owned Indian subsidiary of UCC, was the final corporate accused. On the day the crime was registered, 5 local junior officers of UCIL were the first company officials to see the inside of a jail. They were also the last. Incredibly, their release on bail after 12 days marked the final day in custody for any Union Carbide representative before or since. Though convictions for negligence were finally secured against 7 UCIL officials in June 2010, each of the convicted were granted immediate bail and remain at liberty, vigorous appeals still pending. The foreign accused in the case, taken over by India's Interpol agency, the Central Bureau of Investigation, on December the 9th, 1984, have fared better still. Though charged with culpable homicide and several other serious offences in proceedings that have been underway for a total of 25 years, not one has faced a single day in court, each having elected to withdraw consent from the process of their own prosecution. Summonses, arrest warrants and extradition requests have all failed to procure their appearance. UCC, a former Fortune 500 company, is a declared fugitive till today, but by dint of remaining abroad remains beyond the law. The only foreign company official charged, Union Carbide Chairman Warren Anderson, arrived in Bombay on December the 6th, 1984, just 3 days after the disaster. On a high-visibility mission of mercy, Anderson carried an assurance of safe passage from India's Foreign Secretary. Anderson and 2 UCIL executives flew on to Bhopal on the morning of December 7th, accompanied by the US Foreign Commercial Attaché, To their astonishment, the 3 corporate officials were arrested upon arrival at Bhopal's airport by the local superintendent of police and kept under house arrest. Criminal charges were formally filed against the 3 in the presence of a magistrate. Anderson was released on bail within 6 hours, bail worth $2,000. It was initially reported that bail was arranged following intervention by the US Embassy. Later reports claim that Anderson's release was ordered directly by Prime Minister Rajiv Gandhi following the personal involvement of US President Ronald Reagan. The bail bond signed by Anderson to secure his release contained charges including Section 304 of the Indian Penal Code, which is culpable homicide punishable by 10 years to life imprisonment and fine, a strictly non-bailable offence. Granting of bail was therefore unlawful. Anderson has never fulfilled his bail promise to return to India. India's first request for his extradition, delivered in 2003, was rejected a year later by the US State and Justice Departments. Freedom of Information documents reveal that lawyers representing Union Carbide and Dow Chemical were the first to hear of the rejection. Another extradition request has been pending with the US government since 2011 without any reply whatsoever. When Union Carbide and the Indian government reached an out-of-court civil settlement in 1989, the $470 million contained no provision for loss of earnings due to illness, no provision for property damage, for medical expenses or monitoring, or any form of punitive element. The average amount of compensation received by each of the gas affected was eventually around $500 per person, even less than that given by the Indian Railways Injury Compensation Scheme. Families of the dead received an average of $2,000. The company's shares jumped $2 on Wall Street the day of the news. The gross inadequacy of the settlement was a direct consequence of the refusal of US courts to hear the civil cases on grounds of inconvenient forum, and the legal delays this inevitably engendered. Around 168,000 legal claims for personal injury and death, worth $250 billion, had been filed against UCC in the US. India claimed damages on 7 counts, including negligence, absolute liability and strict liability. India alleged breach of duty and specifically asserted that UCC owned, designed, constructed, operated and controlled the Bhopal plant. India also alleged that UCC contributed to the disaster by use of defective safety systems, instrumentation, warning systems and operating and maintenance procedures. And the intervening years have garnered huge amounts of evidence to establish all of these claims categorically. Preliminary discovery produced evidence to support the allegations also. The company's corporate charter and policy manuals revealed that UCC pursued an explicit policy of control over its subsidiaries, which were defined as any affiliate in which UCC held more than 50% equity. Majority equity in UCIL enabled UCC to carry a majority presence upon its board, through which it could heavily influence UCIL's management decisions. None of this was sufficient to persuade US courts, who ruled that there was no real interest in hearing the claims in America, whilst deferring to UCC's invocation of separate legal personality, namely that the Bhopal plant was managed, operated and maintained entirely by Indians in India. The chief affidavit relied upon by US courts in reaching this conclusion was in 2011 proved entirely unreliable when the author of the affidavit completely reversed his position before an attorney. Armed with its US rulings, UCC was able to threaten appeal in US jurisdiction of any Indian judicial initiatives it considered in breach of its due process rights. This potential forum hopping was cited within 3 separate Indian Supreme Court cases and orders justifying the necessity of a settlement that in the end was less than 15% of the $3.3 billion India had originally filed suit for. Even if the gas disaster had been averted, Union Carbide's chemicals would still be damaging the bodies of thousands of Bhopalis. According to former workers of the factory, over 15 years a massive amount of chemical substances formulated in the plant, including pesticides, solvents, catalysts and other substances, as well as byproducts, were routinely dumped in and around the factory grounds, causing pollution of the soil, water and air. Between 1969 and 1977, byproducts and waste were dumped into pits situated in the factory premises, covering 21% of the total site area. In 1977, disposal ponds were constructed 400 metres north of the plant, covering an area of 14 hectares. Several thousand tonnes of toxic wastes were henceforth dumped at these sites. By 1982, that's 2 years before the gas disaster, UCIL was informing UCC of major leakages from the ponds. In 1983, following the death of several cattle, a local attorney wrote to management of potential legal action due to contamination, threatening the health of local communities. The management termed the claims baseless. By 1989, UCC and UCIL had undertaken secret tests of soil and water around the plant and discovered samples to be lethally toxic, but managers covered up the results and did nothing to address the sources of pollution or warn local communities drinking from wells the company had already identified to be suspect. Instead, in 1994, UCC divested itself of its Indian shareholdings and declared the pollution it had collaborated in causing and covering up to be the state government's problem. Today, the toxic plume caused by the thousands of tonnes of underground wastes has contaminated community wells with carcinogenic and mutagenic organic chemicals at least 5 kilometres away from the plant site, affecting at least 40,000 local residents. In 2004, an environmental suit was filed by 17 plaintiffs against UCC New York, seeking injunctive relief for on- and off-site plant remediation and medical monitoring, and based upon 4 theories. That UCC was a direct participant and joint tortfeasor in the activities that resulted in the pollution. That UCC worked in concert with UCIL to cause, exacerbate and conceal the pollution problem. That UCIL acted as UCC's agent, and that UCIL acted as UCC's alter ego, justifying piercing of UCIL's corporate veil. In June 2013, the US Appeals Court finally concluded, against a volume of countervailing evidence obtained through discovery, that Union Carbide is not the correct entity for litigation, and that there existed a distinct separation between UCC and Union Carbide India Limited. Human rights lawyer Louise Christian remarked that the decision should shame the world. Despite 3 decades worth of legal travesties, dirty politics and gross miscarriages of justice, Bhopal survivors have maintained an unbending determination to obtain remedies and restitution via legal processes. Purely as a result of survivor group interventions, criminal, civil and environmental cases remain alive in Indian and US jurisdictions today. In 2010, India filed a curative petition to reopen the 1989 settlement with UCC, claiming additional compensation of over $1 billion. Both UCC and Dow Chemical, its new owner, are named in the suit. In November 2013, fresh environmental claims were filed against UCC in New York, utilising compelling new evidence. Last month, March 2014, the Dow Chemical Company was issued notice to appear in criminal proceedings in Bhopal to explain the non-appearance of its 100% owned subsidiary UCC. Dow, which terms itself a mere shareholder of a distinct and separate legal entity, must appear on July 4th, 2014, or expose its Indian assets to sanctions. Alongside campaign actions by Bhopal survivors, which number in the hundreds, a public interest environmental case filed within the Indian court system in 2004 has also been instrumental in preventing Dow Chemical from pursuing a $5 billion strategic investment in India. The Bhopal legacy has caused Dow's brand rating to fall 300% in the last 6 years, during which time Dow has made it into the top 20 corporations targeted by activists globally. Its management continues to deny two shareholders and regulatory authorities that Bhopal is causing any financial, operational or reputational impact upon it. It's also regularly denied that there are any legal cases outstanding. The struggle for accountability will continue. Bhopal survivors have vowed to fight on till their final breath, until some sort of justice is served. Thank you very much indeed. I just wanted to add that Amnesty International last month published a wide-ranging report on 4 different cases of corporate abuse of human rights. Bhopal is the principal case study, and it's a fantastic overview of all of these issues and brings everything right up to date, and also contains a series of conclusions and recommendations relating to inconvenient forum issues, separate legal personality issues, and access to information and other key problems in accessing remedies for communities impacted by human rights abuse by corporations. Thank you very much.
Thanks, Tim. That's got things off to an excellent start, as you put it. A case study of conspiracy to obstruct the course of justice, grossly inadequate compensation, dirty politics. We thought Bhopal had been resolved before now, but as you pointed out, it's an ongoing saga, deserves to be kept at the forefront of this study. I'm sure folks will have many questions to raise about that, but I'm proposing to deal with the questions to all 3 speakers at the end of this session. And I'll turn to our second speaker, Elizabeth Owens, who's from Client Earth. As many of you will know, Client Earth has been very prominent in litigation over recent years, and we're fortunate to have not 1 but 2 speakers from Client Earth during today's session. Just shows their significance. But Elizabeth's going to be talking about litigation as a tool to change corporate behaviour. We hope it's a success story, but we'll listen to hear whether it is or not. Thank you very much.
Thank you very much, and thank you for inviting me to come and to talk about this today. I'm going to talk about using litigation as a tool to change corporate behaviour. Now, I'm going to talk about this in the context of climate change, and that's for 2 reasons. I think it's always helpful when thinking about a law to think about it in a specific context. And secondly, I have been focusing on climate change in the work I'm doing, so it's the area that I'm best equipped to talk about. So to set this in context, this week we've had the Intergovernmental Panel on Climate Change, their part 2 of their 5th report on the impacts, adaptation and vulnerability. The next report is due out next week on mitigation, so actually this report didn't focus on mitigation, but we should be getting that on Sunday. Now this report says that the impacts of climate change are already being felt, and some of the examples are up there on the slide. They also paint quite an alarming picture for the future, including coastal flooding, submergence, erosion, drought and water scarcity, heat stress, that's human heat stress when we have heat waves, particularly in urban areas, landslides, loss of permafrost, food security being threatened, and loss of biodiversity. The report specifically identifies a list of key economic sectors and services that it anticipates are likely to be most affected by climate change. And those include transport, agriculture, fisheries, the health sector, tourism, ski resorts, for example, is something they pick out that's likely to be significantly impacted, water services, and perhaps most importantly, the energy sector and the insurance industry. Of course, the insurance industry sits behind a lot of this, ensuring the risk of physical damage to property and that kind of thing. So the insurance industry is an industry that's likely to be heavily impacted. So the types of risk that these companies are facing include physical risk. So here we're talking about physical risk from flooding, fire, other kind of adverse weather events, extreme weather events, things like Hurricane Katrina, where those sorts of storms are exacerbated by climate change. We've got risks to natural resources. Obviously, many industries rely on things like fresh water supplies, crops being successful, and often those things are quite far down the supply chain or maybe coming from the other side of the world. So even businesses in the UK need to be thinking about how changes in climate in Africa or in Asia might be affecting their business here in the UK. Technological risk, we might see that we see rapid changes in renewable technology, for example, which may change the way our energy is produced. Regulatory risk. This is a particularly significant one. I don't know if you'll be familiar with the work of an organisation called the Carbon Tracker Initiative, but basically they are arguing that if the world gets itself together in the next couple of years and manages to agree a carbon budget that would be substantial enough to restrict global warming to 2 degrees above pre-industrial levels, then the general view at the moment is that about 3/5 of the currently known fossil fuel reserves that fossil fuel companies are currently listing on their asset sheets will have to stay in the ground. Now, the argument here goes that these assets are listed on companies' asset sheets and are currently incorporated in their share price and their company value. If the governments of the world come together and manage to reach an agreement that means that 3/5 of these are going to have to stay in the ground, then Carbon Tracker argue that these assets will become stranded and are unburnable, and you've got a situation where you've got a carbon bubble sitting on the asset sheets of these companies, which will ultimately need to be written off, having a massive impact on their value. So that's what we mean by regulatory risk. Reputational risk, that's obvious really. As the evidence increases for climate change, we can see people maybe switching their energy suppliers or wanting to move their investments away from fossil fuel companies purely on the basis of reputation and kind of ethical considerations. And then we've got litigation risk, which is being sued for causing climate change. This is still in a fairly early stage, but we've seen some cases in recent years in the US. And a good example is the island of Kivalina. Kivalina is a town in Alaska which is based on an island which is surrounded by Arctic sea ice. Now, the Arctic sea ice protects the island from erosion by the sea, but the residents of Kivalina are finding that the ice is melting earlier every spring and freezing later every winter, which means that the island is being exposed to the sea for a much longer period every year and is being eroded dramatically as a result. And the view is now that actually they're going to have to completely move the town of Kivalina to somewhere else because in 30 years it won't exist anymore. So the residents of Kivalina have got together to bring a case in the States against Exxon and various other large energy companies, claiming in tort for the cost of moving the town of Kivalina to somewhere else, which, as you can imagine, is billions of dollars. That case went all the way to the Supreme Court in the US, but failed on the basis that they were running it under federal law, and the court found that the US Clean Air Act displaces the effect of federal law in this area, so you cannot have a federal nuisance claim in this area because the government has brought in the Clean Air Act. Now, it's widely anticipated that litigation is going to start again at state level, so I think that they'll probably be shopping around looking for a favourable state law and it will be recommenced. And we can anticipate that these sorts of cases are probably going to crop up in other countries around the world. So this is the sort of risk that fossil fuel companies now need to be thinking about. So how do those risks interact with company and financial law? This may be very basic to some of you, but